many of you things may happen. Either you will leave the video open while sleeping, or you will, just okay, let me just let Arif Fadlan. So so yeah, I leave it to you basically. Yeah. But as a disclaimer, it is just a simple video lah. It is just a simple video. I did not put anything in. If I want, I will get my daughter to do it. But for the purpose of time, then I just dump that recording, yeah, as is, yeah, on as is basis. Okay. Okay. Let us now have a look at the. Is there anything you want to share? Maybe. Have you read anything from any recent news story? Something which interests you? You may want to share and give comments if you wish. Yeah. Never mind. If you are not ready now. Okay. Share. Oh, I don't know if I mentioned to you on the weekend. On the weekend, my interview was actually featured in the Star. Oh yeah, I did not alert you, but I will share with you my interview. Yeah. So the Star Sunday, they were running a report on this pandemic, on the issue of data tracing, privacy of patients, and then the logbook, My Sejahtera. So I will share with you that very soon. You can have a look later because it's very relevant as of the current situation. Yeah. So yeah, I shared with you much earlier. Okay, now I'm sharing. The good thing about this, yeah, is that it is very real time. Yeah, I can share with you now. Now you have it on your mobile. Okay. Oh, not. Okay, there are two files. Yeah, because two big pages in the Star. One already went through. Coming up. Okay. Because I just highlighted the situation. Yeah. During this pandemic, people are faced with this fact that their data is being followed, yeah, being traced, especially if you are infected under suspected, yeah, infection. If you are suspect, people under suspicion
PUI, sir.
is tracing, yeah, the data. Yeah, the word is PUI. Apa PUI, Shakir? Person under
Person under
isolation.
investigation.
Ke investigation. Investigation. Okay. So yes, if you have a PUI, then your data will be collected, right? Now, in fact, common people's data are being collected now from time to time, wherever you go, to premises and so on. So the issue here is what about the data protection? How is the data being protected? Is my Sejahtera safe and secure? What about the responsibility, knowing that the government, because this data actually belongs or being processed by the government, yeah, Ministry of Health. The fact is that government is not subject to the PDPA. That makes things a little bit more complicated, because the government is not subject to the PDPA, to the Data Protection Act. But that does not mean they are free to make use of our data for anything. Yeah, meaning there is still a fair practices to be followed by the government, especially having to reflect what is in the PDPA. So my premise is, or my argument is that even though the government is not subject to the data protection law in Malaysia, yet they have to follow, they rather comply with the best practices that we have under the PDPA because of two reasons. Number one, because we don't want to see a double standard. We don't want to see a double standard. We've been telling private sectors to comply with certain principles, but at the same time, the data in the government sector is being less protected. So we don't want that to happen. Therefore, even though the law doesn't apply, but yet the government has to make it as a practice, how you collect the data, how you store data, how you disclose data, and so on and so forth, reflecting the same principles, at least the minimum principles as we have in the Act. So that's the first reason. The second reason, we must know that data privacy is not only regulated by PDPA. It's not only regulated by the Data Protection Act. Data privacy, as a matter of fact, can be a basis of civil law action. Okay, so even though the government is not subject to the PDPA, the legislation, yet people would or may be able, meaning it is open for people, to sue governments or government officers, under the common law of breach of privacy. So in order to be safe, then you better have a good, governance, of the data. Okay, this is similar to any government agency, including police, including whichever ministry. So they are not subject by the PDPA, but it is preferred that you are following on similar principles. Okay, as a matter of best practice and to be in the safe side. There is among the concerns that I shared in the newspaper report. Um, Also to say that this contact tracing is not similar to surveillance. We must not confuse the two. We must not confuse between contact tracing on one hand and surveillance on the other. Of course, we don't want surveillance. We don't want people to live under the assumption that they are being surveilled. Surveil means you are being watched. You are being watched by government or by anybody else. We don't want this to actually happen. So contact trace, this data collection is for the purpose of contact tracing, meaning if it is needed for the purpose of informing about some infection incident, then it is only to be used. But it is not used for the purpose of surveillance. For example, you put the MySejahtera or whatever device and method outside the premise, but at the same time you actually want to control, or you want to stop people from some movement because you want to check if anybody is supposed to be restricted. So it is quite a different function. We must not confuse. For example, you want to use it for the purpose of controlling okay, one example is about illegal immigrants. This is situation which can be complicated. If you use MySejahtera or all this data collection for the purpose of spotting illegal immigrants, for example, and to catch them, then you are actually deviating from the original purpose. And this original purpose is mentioned under MySejahtera or whatever apps. Actually, there is a statement of the original purpose why we collect your data. Of course, for the purpose of controlling the infection, the virus, and so on, but not for any other purpose. That is one of the principle to ensure that people are not feeling under you know, under this assumption of being surveilled, being watched, you know, um, and so on. Yeah, that is also among others my points when I was interviewed by the Star. Okay.
Prof, I got
Right.
one question,
Yes.
Prof.
Okay, Sundar.
When we are trying to retrieve information from these so-called MySejahtera, uh, are
Yes.
there any exceptions, which I read in Evidence Act, illegal obtain evidence? So can we use such provision to legalize obtaining these MySejahtera information? That's all.
Okay, that is where the intersection of issues, yeah, may come. As far as the principle of fair and lawful data collection is concerned, those data that you collect must only be used for the purpose it was intended. Yeah. And if you don't do that, it is either we are violating the law of Data Protection Act, or for the government agencies, since they are not subject to it, you may breach the privacy, the common law of privacy of people. That is the risk. But then, of course, you, from the perspective of the authority, this is a good data, we want to use it for something else. That is another area for you to fight. Yeah, meaning you want to use a data or an evidence which is considered wrongly used, considered wrongly taken for another purpose. As you mentioned, it is called illegally obtained evidence. Yeah, of course, in Malaysia, we have seen cases where they allow, isn't it? They allow illegally obtained evidence to be used and admitted in the court. But to me, it is still, you know, case to case basis. I mean, and the court would still have some discretion to see whether or not to allow it. Yeah, but if you can, now let us see it from a wider perspective. If our people know that this data that we have been collecting from time to time throughout this pandemic, you know, months of pandemic, if they realize that these data are also to be used for different purpose, what do you think people will do? We are discouraging them, you know. We are discouraging them to reveal the data at the time when we really need it, which is mainly for the purpose of, yeah, constraining the pandemic, yeah, putting the stop on the pandemic. So I hope this doesn't happen lah. I hope the government, when they have this chance, even though they have this chance, they still put the priority of this pandemic control as the first priority. Just like some people who are thinking they want to go for some political movement, and or you know, some political uh, endeavors, but if it is at the end harming, yeah, the public health, then I think somehow they should see, you know, other way, you know, other way. We already learned so much from Sabah, isn't it, Mr. Sundar? Yeah. So yeah.
It's true. It's true. Prof.
Exactly. So okay, that is some quite a talk on my recent interview. But lately, I mean, in future, near future, we will be talking about it again from the perspective of data protection principles. Let me now take you to our syllabus, yeah, by showing uh, this blog, yeah. Okay, now I'm taking you to this. Okay, do you see it now?
Yes, Prof.
Yes, Prof.
Okay, thank you. This is our dedicated blog for this dedicated blog page for this class. Yeah, law 7435 cyber law. So we are here already. Look, it is good for you to have, if you have downloaded all this. Yeah, these are among the main readings. Okay, these three things. Then we are done with this introduction to the internet and internet governance. Now we are here. Okay, let me just, okay, this one, I don't have a specific slide for this topic one, topic two. But later on, if we can cover topic three, then I have the slide. The one that I sent you is for topic three, okay? Topic three, internet content regulation. But they are very related, very interrelated. The topic number two is very general question. So after we understand about the internet, about about the architecture of the internet, and then the roles behind the internet, isn't it, under the internet governance, and also people who are contributing to the way internet is the way internet is today, yeah. Then we realize that uh, internet is a subject to many stakeholders, yeah. And this is what we must not miss for cyber law students, because if we don't have this understanding, many cyber law students, I realize, not only from you, especially from others, because if you learn from me, I would have mentioned this. If they learn elsewhere, but they don't start with this issue of internet governance, how it is globally structured, then they will jump to the issue of law, yeah. They will talk about how to regulate the internet, yeah. In my class, this comes later, like today only we cover it, you know. Only today we cover, because we believe that law is only one option. There are many other options that can be considered for you to regulate the law, sorry, to regulate the internet. But now we have come to this question, which every cyber law students would want to know. um is there a law, is there a way to regulate the internet, and how to do that? Or maybe something which is very or more basic to it, is internet, or should the internet be subject to law, yeah. Then I want to highlight to you this, of course, this is more like theoretical and conceptual discussion. Even though not many people now are asking this question. Why is that? I mean, today, yeah, because we already see that more and more laws related to cyberspace are being legislated, and every country had started, or had actually enacted laws, one law after the other, one law after the other. The law which is specifically designated to the cyberspace environment, yeah. For example, computer crimes law, yeah. There was no such need for computer crimes law before. We just have this penal code, isn't it? Or then electronic commerce law, yeah, electronic commerce act in Malaysia. In India, they have Information Technology Act, ITA, very big law. Yeah. In Indonesia, in any other countries, they start to have all. And all this movement started sometime towards the end of the 90s. Yeah. You must understand the the condition at that time when internet was actually innovated, when actually internet was created. It was so innovative. It was created by techie people, technology experts, mathematicians, engineers, system engineers, and so on. They never talk about law, isn't it? And they never ever thought that this should be regulated. This is actually what happened in the past. There is a common belief in their thinking that the internet should be open, an open space to be benefited by every people, everyone in the world. The moment they see actually that everyone start to interconnect, Yeah. So it was not built by this um, understanding that there should be a law on the internet. This is actually how it started. Yeah. And then this discussion then came very vividly starting somewhere in 1995 and 1996 in the United States when they had legislated a law called Digital Millennium Communications Act. Digital Millennium Communications Act, DMCA. So under this DMCA, the government started to put some regulations, for example, relating to copyright protection in the internet. You know, and it happened when people were so, you know, excited that we have this common platform, we can share almost anything. Works, you know, in the past, photocopying book was not very easy. You use a photocopy machine, but this time around, once you have this soft copy, you can simply send to people. And then movies, videos, films, songs, and so on. They were easily disseminated. And then comes this law that it is actually copyrighted, that it is actually violating the copyright laws, and so on and so forth. Then you must understand how people were taken aback by this. And then not only copyright was the issue or was the concern, but also on the issue of porn materials. Porn materials. Of course, in the United States, this is something of public consumptions, yeah. Except if you are a child and the material is relating to children, then it is a no-no. Yeah, it is a big no-no. But to them, other than that, it is just like a freedom of expression. We have to know that that is their values. So they have been, you know, freely distributing this and that, allowing people to have access. And then comes this law putting some restrictions. So they don't really like it. And then another issue, the government also imposed liabilities to some extent on internet service providers. Yeah, our friend last week, yeah, presented about internet service providers. So these people were angered. They are making business here, and they believe what they did was to open up the world to people. But yet now they are potentially liable for the content. Yeah. So this in 1995-96, because of this DMCA, comes this issue, you know, that the government has put lots of restrictions and censorship to the internet. That's why comes this, uh, the one I highlighted here, a declaration of the independence of cyberspace. This was in 1996. I showed you here. Sorry, it's already here. Okay. Okay, this is hosted by this NGO, Electronic Frontier Foundation, EFF. Yeah, EFF, Electronic Frontier Foundation. This one non-government, very reputable organization, of course non-government, and they have taken side normally against government, yeah, in many ways. That's why now John Perry Barlow came up with this very rhetoric declaration called a Declaration of the Independence of Cyberspace. Who is John Perry Barlow? He was first known as a lyricist, as a musician, yeah, as a musician. But also he was very active in this social activism. So people also know him as a social activist, John Perry Barlow. Yeah. So John Perry Barlow, I remember when I was a kid back in Jakarta, I remember his name, but as a person who wrote a song. So some of his songs were well known, yeah. So he came up with this. I want you to read later in your own time, in your own time and place. But basically, he came up with a protest. Yeah? He was protesting against the initiatives taken by governments. Not he did not single out United American government. Actually, it was directed to any governments in the world, arguing that you should not regulate the internet. You should not, because it is meant to be a free space, an open space. So in this writing, if you print it, it is less than 3 pages, just 2.5, I think, very short. Actually, a nice rhetoric from his perspective. You try to read, yeah. In each of this paragraph and line, there is some points, or there are some points to highlight. He was arguing that this internet should be let open, free, no intervention of governments, any governments in the world, no intervention of law. He came up with this ideas. It is important for you to understand why he thought like that, because this rhetorics will inspire you about those concerns people have against law being introduced to the internet. And surprisingly, even though this declaration was made in 1996, I still hear people using similar arguments that he put in his rhetoric to protest or to argue if there is any attempt, yeah, to regulate something from the internet. So if you understand this rhetoric and see from the very beginning, then you will realize, yeah, more and many of those arguments people put up are actually not very far from what he wrote here. Yeah. For example, he was arguing that the internet was supposed to be let free and open because it is meant to be like that. It is meant by its architects, yeah, to be an open space, and it is not for the politicians, yeah, to regulate. Why? Because this is a space independent from the real life. That is one of the issues. Is it true that internet is a space independent from the real life? That is for you to gauge, for you to look further. Yeah, people say, "Oh, this is our life." In fact, you can have a second life in the cyberspace by assuming different characters, different names, different identities. But does it, or is it enough to tell that whatever happens in the internet does not concern with the real life? Of course, I beg to differ. Yeah. In Malaysia, recently, yeah, a teenager was posting a post on Instagram. Of course, Instagram is part of the internet. It is not a real physical life. So he was asking his people, his friends or followers, you call it, yeah, in Instagram. I'm not too sure. In Facebook, you call them friends. On Twitter, you call them followers. On Instagram, I don't know. Is it friends also or followers?
Followers.
Followers.
Followers. Thank you. So this teenager was telling her followers, guys, yeah, asking advice. Should I choose between the two? Should I choose D or L? So she actually posted two options, two capital letters, D and L. Which one I should choose? Many followers, or rather more followers, advise her to choose D. So they just say D, D. Then some few got L and D, D, L, L, D, D, L. Then at the end, D outnumbers L. What does D mean? What does L mean? D stands for death. L stands for life. So he was actually asking advice. Should I live or should I die? Then what happens? After the poll, this is a poll they use on Instagram, because D outnumbers L, then she committed suicide. When did it happen? Only recently, less than a year ago. Where did it happen? In Sarawak, Malaysia, not in cyberspace. You don't say that she died in the cyberspace. Did she die in the cyberspace? No, she died in real. She was from Sarawak. So this is. I just want to show you whatever happens in the internet. There's surely some connection. Yeah, some things that can also happen, or something affecting or affected by the real life. So I want you to read this John Perry Barlow's writing. Why did he say that cyberspace has to be independent? And please highlight each and every arguments that he had, and think about how to argue, or maybe you want to agree with him. Up to you. Up to you. If you want to agree with him, I'm not being a bad influence to you by changing your mind, but this is academic exercise. You may want to argue, you may want to agree to some extent. Then let be it. Let us discuss. Let us debate. Because John Perry Barlow also was saying, among others, of the reason is that this internet does not fall into any of these countries' jurisdictions. Yeah, you have no nationality to enter into the internet. In this village of the internet, you don't need to have a passport, to show your citizenry. And the law, when you are talking about law, it is only applied or applicable to specific localities. How can you then impose your law on these global citizens? That is also one of the arguments. Brothers and sisters, this is a postgraduate class, so I'm not going to explain each and every points that he raised, but I want you to read and have your, or form your judgment and arguments. We may want to discuss about this in future seminar, to finally see, I mean, what do you think about this? Okay. But then part of this important topic is also the question. Okay, let us now forego what John Perry Barlow says, because if you totally agree with him, then you're not supposed to be in this class, isn't it? Because you don't believe there is, I mean, you don't believe law should be imposed, or there should be a law on cyberspace. So whether you want to be attracted by his thought or not, I will set it aside. Because as I said, this discussion was less being used, by less being questioned by people today, because we already see governments keep on legislating cyber law legislations. Now there's also another debate. It also started somewhere in 1996. So I must tell you, a lot of things actually started in 1996. Even though in Malaysia this cyber law is still new, sometimes we discuss a lot of things, but you must know that so many things that we discuss over here about freedom of expression, about freedom of information, about privacy, about domain name and ISP liability that we discuss after year 2000 and above. They had been discussed much earlier, yeah, in some other places. So it is good to learn from them. So I'd like to highlight to you the following questions here. Okay, as you see, topic number 2. I write the question here. Let me just enlarge this. Is internet subject to rules and laws? So this one you will understand. First, you need to read John Perry Barlow's article first, because there is this follow-up question: why did John Perry Barlow declare the independence of the internet? Yeah. So these, okay, similar question or follow-up question: how the law and the internet affect each other? And this is also another food for thought to understand. The fact that the internet is in its virtual space, not defined by physical borders, right? But if you understand how the internet is structured, you will also realize that there are spaces where local players exist and play their roles. Who are local players? I mean, in each country. Like for example, Malaysia, we have, for example, domain name, local domain name registrars. These are Malaysian or Malaysia based. We also have the ISPs, which are supposed to be local. Yeah. So if you get a access from this ISP, meaning you are dealing with this licensees, yeah, the Malaysian licensees who are licensed under the Malaysian law. And then if you're talking about using the internet in Malaysia, meaning you are more or less dependent on the internet infrastructure which is provided in every country. And of course it can be different in terms of sophistication. The internet in this country compared to internet in other countries. Some countries have much faster internet than us, but many others are having much slower internet than us. Why is that? Because of the infrastructure in the specific jurisdictions. So look at this situation. Yeah, looking at this situation, is it safe for us to say that the cyberspace that we know it is totally independent from the real space? And whether or not they are actually affecting one another, yeah, between the internet, the virtual space, and the real space. Yeah. So if we do see or realize that there is this interrelations between the real space and the virtual space, then most likely we also will have an affirmative answer for the question of interrelation between law and the internet, between what the Malaysian governments, for example, legislate on the internet, on the contents of the internet, on the licensing of the internet, on the whatever behavior on the internet. Then we would see that all these local laws will certainly have effect, at least on the behavior of the internet users in Malaysia, right? So that is how we see the interrelation is there. And now a very interesting question. Okay, let's say now we agree that internet can be regulated and it should be regulated. Now comes the next question. Yeah, how do we do it? How do we go about it? And that's why now we see the next point in this topic. What are the debates that happen between Easterbrook and Lessig on the law of the horse. I refer you to these two articles. One is written in 1996 by Frank Easterbrook, yeah, published in University of Chicago Legal Forum. Yeah, it is a journal, yeah, entitled Cyberspace and the Law of the Horse. You know horse. Yeah. It was written in 1996. And then I also want you to see the responses given by this second article. Okay. First, it was Frank Easterbrook. Who is Frank Easterbrook? He was a judge in Chicago, in the state of Illinois. Yeah, this is one state. And also he was a lecturer in Chicago Law University, in Chicago Law School. Yeah, Chicago University. His writing, or actually it started with his speech. Yeah, his speech was then commented by Professor Lawrence Lessig in 1996. So there's a 3-year gap in between. Yeah, he wrote this article published by Harvard Law Review in 1999, entitled "The Law of the Horse and What Cyber Law Might Teach." This is very interesting. These two articles I purposely highlighted to you because they represent the debate as to how the law should respond to the phenomenon called cyberspace. Yeah. So you can actually say that cyber law was actually formed at this era, you know, this era, 1996 to 1999 or 2000. And before this, we didn't have this idea of cyber law, because before this, we normally use other law, for example, telecommunications law, you know, law and legislation related to telecommunication industries. Bang, ini. So cyber law had only maybe born at that time. Yeah. So I can highlight to you, these are among the two classic writings. Yeah. To understand. Let me now summarize. Yeah, because I can't really say much, but most of things actually beg to you to read it. Yeah, and I already give you all this link. You must know that whenever you click this one, you click new tab, it will take you to this one. Yeah. Sorry, this is the same one I said. No. If you click this one, it takes you to this. Yeah. University of Chicago Law School, Cyberspace and the Law of the Horse, 1996. You see? You have everything. Don't worry. Okay. Now let me summarize. Frank Easterbrook. This is interesting. Or rather, I'd say funny. Yeah? Why? Because he was actually asked to give a speech, yeah, like delivering a keynote, you know, like a speech in a conference. The conference is entitled Conference on Law and Cyberspace. Yeah, law and cyberspace. So at that time, of course, people were arguing that, okay, we have this new genre of law where the law, we need new law in order to regulate this internet, you know, or deal with restrictions to some extent on the internet. And then this Frank Easterbrook, being a judge, also being a lecturer, he was given this opportunity to come keynote. And then what actually he was saying in his note, in his address, is that he was saying that we don't actually need cyber law. To some extent, it took people by surprise. Yeah, because the way he said it was very academic lad. You need to read the article. He was saying, no, we are not going to create the law called law of cyberspace, or also you might want to call it cyberspace law or cyber law, whatsoever. We don't really need this one. Yeah, it is not like law and economics, for example. He said, because law and economics means you are actually having a real problems between the two things, between the law on one side and the economics on the other side, and there are some things that needs uh to be reconciled. Yeah, or maybe law and art, or law and philosophy. Okay, but law and cyberspace, or law of cyberspace, no. Frank Estabrook argues that this is a wrong approach. We don't need a law of cyberspace, just like we don't need the law of the horse. That's why the title is Law of the Horse. We don't need the law of the horse. This is a metaphor that he was using. How is that? Look, if you have a horse, then certainly you will do a few things with the horse, right? You're going to keep it. You're going to keep it in a farm, and then you are going to feed the horse, and then you are going to use the horse for certain purpose, and maybe you will take the horse as a vehicle, or you may take the horse for the purpose of work. Okay, in whatever you do with the horse, the question is, do we need a specific law for it? The answer is no, because there are already existing laws which are able to, deal with whatever you do with the horse. For example, you want to buy a horse. We don't need a law of a horse. You require the principle of contractual law. You want to buy a horse from someone, then your interaction and transactions are governed by the existing contract law, isn't it? Or you may want to rent the horse, sorry, the house. You want to rent the horse, then also the commercial law of renting and so on will apply. Now you want to, okay, keep the horse, you want to feed it, then certainly you will need to abide by some law and regulations regulating the farming in general. And then, for example, the horse, you want to use the horse to the road, then certainly there is some law to deal with that, which is traffic law. You don't need a law of the horse to tell you what to do and what not to do with the horse if you take it to the road. But you have the traffic rules, which will tell you, if you take the horse, what can you do and what you cannot do. Yeah. If the horse happens to kick someone and get him injured, then we have another law of negligence. Or if you use the horse to attack people, then you use the law of the criminal code. So he was actually telling, we don't need law of the horse, because whatever you do with the horse, we will use the existing law and principles. Then he used this metaphor for technologies like the internet. You don't need cyberspace law. You don't need cyber law. All what you need to do is look at your contract law, look at your property law, enhance them, and then apply it to the computers, apply it to the interaction in the internet. So if we are to use his argument, basically we don't need to legislate any specific law relating to the computers or to the internet. It is sufficient for you to improve and change criminal law, improve defamation law, improve property law, contract law, copyright law, whatsoever. Yeah. So he argues like that. He said that there is no way we can regulate the internet as such. Right? So with this, I summarize already. Yeah, I just summarized what Frank Estabrook was saying in this article. Sorry. Yes. Sorry, not this one. Yeah. Cyberspace and the law of the horse. Yeah. Maybe in future you should be able to explain what is meant by the law of the horse in this article and relate it with the idea of cyberspace law according to Frank Easterbrook. Yeah. I hope you are able to pick that idea. Now I'm taking you to, yeah, is there someone trying to communicate? We get some signals here from Mars or from somewhere? No, yeah? Okay. Just ensure. If you want to talk, okay, just unmute yourself. But if not, then just mute yourself safely. Okay. Are you all following?
Yes, sir.
Yes,
Yes.
Prof.
Thank you. Yeah. Please bear with me. I'm doing much of the talk this
Yes, Prof.
time, but later it will
Yes,
be your part. Yeah.
Correct,
That's
Prof.
why it is. That's why it is called lecture, because you are going to listen lectures. But of course, in this master class, lectures is just one part. I mean, others will be coming from you. Later on, we will have more seminars in future. Among others, we will discuss all this issue. Yeah. Then I'm taking you further to this, to the answer by Lawrence Lessig. This one I highlight here. You still can see my screen, right?
yes,
Yes,
Prof.
Prof.
Hear you.
Okay, thank you.
Yeah,
So
yeah.
Lawrence Lessig, based in Harvard, yeah, he was in that conference listening to Frank Easterbrook. So he had a lot of disagreements with what he said. Then he wrote this article. Yeah. Among others, of course, he was answering. Number one, this is not just a normal horse. He was trying to say, look, the internet that we are talking now is not as simple as a horse. Yeah. If it is about a horse, then I think we can agree that nothing new should be done. Yeah. But he was actually arguing, he was actually trying to explain that this ain't a horse like you understand it. That this and this one is a technology that will change a lot of things. It is not similar to other broadcast media like radio, television. It is not simply a gadget for communications like telephone or telegram, but it is a comprehensive new space where people are allowed or enabled to interact one way or another. And more importantly, it is an open infrastructure which allows people to keep on developing the internet the way they want. This is not very easy to take the way they want, because if you allow the internet just to develop the way these people, the architects of the internet want, and this is from the perspective of law. So are we allowing in future that the internet will be increasingly beyond the control of people? And in fact, this is already partly true, with this AI, for example. Why? Because the internet allows the massive collection and disclosure of big data, and allows machine to learn with the algorithms and mathematics develop, and at the end creating another entity able to do a lot of things that we never thought before. This is also very much related. You talk about AI, it is so much related to how the ICT is enabled. So what Lawrence Lessig was trying to say, that this ain't a horse. This is not like a normal animal. We need to have we need to anticipate. And in this article, he came up with some examples. Yeah, why it is different. he was arguing that the internet is still possible to regulate, because Easterbrook was saying no, it is impossible to regulate the internet. Yeah, but Lawrence Lessig argued, yes, we can. There are many ways, not only one way. There are many ways. You have a norm, you have a market, you have a technology, and you have law. Each of them can be used to regulate the internet. This is a very beautiful thinking, yeah, by Lawrence Lessig, of how we see the internet and how we can put a regulation, or how we can regulate. So at the end, he was arguing, he was disagreeing with Easterbrook in many ways, and among others, saying that we really need to think of, having new genre, new types of law that are capable and designated specifically to target and to settle, problems in the internet, including the copyright infringement in the internet, privacy, cyber crimes, and so on and so forth. So that is what I say, regarding this, debates between Easterbrook and Lessig on the law of the horse. So basically, we can pick from this debate saying that, yes, there are many ways to regulate the internet, and one of them is by law. So how we put the law? It is not simply the general law, like what Judge Easterbrook was saying. Somehow we need the law of the internet here, but not like how we don't need the law of the horse, because these are quite two different things. Internet is very dynamic and capable of creating a lot of controversies and issues in the future, which is quite proven, and this thing, it happened between 1996 and 1999. Yeah. Then 20 years after, you see a lot of things are still not settled in the internet. Okay, so that is, I think, with the time constraint also, I think the summary of the debate when we have under this topic of law of the cyberspace. So further on, please go further. I think this is considered as a additional debate lah, between Johnson and Goldsmith on the law of cyberspace. Actually, it is similarly echoing or reflecting the debate now between these two articles, one written in 1996 by David Johnson and David Post, Law and Borders, and second is Jack Goldsmith was wrote also in 1999, again, between 96 and 99, against cyber anarchy. Yeah. So in the first one, Law and Borders, also it says that it is not easy to regulate the internet because you have to consider the jurisdictions and so on. Yeah, Law and Borders. Yeah. Okay. Never mind. We can leave this to other time for readings. And Jack Goldsmith here. Against cyber anarchy. See, the Communications Decency Act, CDA. This is the law I was telling you. Okay. So never mind. I'm not touching this in detail because I think it's being reflected from my article, from my discussion between Frank Easterbrook and Lawrence Lessig. Yeah. So basically, from this topic, you should be, or you are expected to understand the debate that happens. So I must say that even though this debate started in 96 and 99, but you will still see the debates, from time to time between people. Yeah, it is like everlasting debate. Yeah, do we really need to regulate this or not? For example, people started to use cryptocurrency. Then some people say, oh, we must regulate it. Others say, no, we don't need to regulate. We don't really need that because it is just one-off. You see? similar discussion and debates, and some other will say, no, we already have enough law to deal with that. Do we really have enough law to deal with that? Not necessarily. Okay, so we need a new law. So is this law to be parked under the existing framework, or is it a new law? It doesn't matter. Yeah, you may want to have a law under banking law, for example, or you want to have a law under securities commission or securities law in order to regulate a cryptocurrency. It is up to you, as long as you have a good law. Or maybe you just want to create a cryptocurrency act, for example. It is up to you, as long as they do good for the thing that you want to regulate. But you must understand, we are dealing with technology here. The law, if we are to put the law, is not supposed to be a barrier to technology. It's not supposed to be a barrier to innovation, because innovation is very much celebrated. It is humane in nature to innovate. We need innovation, isn't it? No, we live with innovation from time to time. So we need a law to carry that innovation, to facilitate that innovation, and to put it on the right track. Yeah, rather than a law which will stop the innovation. That's why at any time we think about law of cyberspace, we should have caution. Yeah, not to create or to push the law to become barrier to the technology, but instead the law should be a carrier to the technology, carrier to the innovation, not the barrier to the innovation. Yeah, law is a carrier, not a barrier. Yeah, that is what we have to consider at all time. Yeah, on how you want to do it. Yeah, depends. Sometimes we just need to improve the existing law. It's okay. Yeah, like penal code on cyber terrorism, we use penal code. On online fraud, then we still use penal code. But sometimes we realize that the existing law is not sufficient and is not enough. Then you have to create a new law. That's why we have Communications and Multimedia Act. We have a Personal Data Protection Act. We have a Computer Crimes Act, Telemedicine Act. This is based on the idea that, yes, we need something new. It is not a simple law of the horse, but we are talking about different kind of horse here, which you need to regulate it specifically. Yeah. So I hope you have that idea clearly. That is about it. Any question? Any comment?
Very clear, Prof.
Very good. So what is expected from you? Yes, yes,
sorry,
please.
Yeah, I cannot open your website in the PDF file.
Do you
How to open this?
open the website in its using this domain name?
Yeah, I already open.
sonnyjuhuda.com/law-7435. Then does it ask you a pin code? Yes, the
Yeah,
pin code is code. Yes, the code
yeah,
is
password.
4309.
Okay, I already enter
4309.
4.
Do you get it? Can you open it now? Okay. I hope you get it, yeah? All right. Is there any comment? Anything from this?
Okay, bro.
Yes,
Thank
no
you, bro.
problem. Okay. What is expected from you from this topic? Number one, you get the idea of how the debate was between those between those who say that internet no need for the law. There is no need for the law. You need to go to this John Peribalo's article and see what is it what is his or what are his arguments. Yeah. Secondly, you need to be able to discuss that. Yeah. Next is Yes, if we need a law, if the law can be applied to the internet or cyberspace, in what way is it? Are we using the general law or are we using a specific law? Of course, as I said, sometimes we need a specific law or sometimes we just need to enhance the general law. So, but you have to, of course, this is a very simplistic statement, but you need to get the idea why it is. Why is it not good to have a specific law according to Frank Easterbrook? Yeah. Or why is it actually necessary according to Lawrence Lessig? Because they actually give a very beautiful, opinions. And this will be able, you can carry further this idea to future. Sometimes we see innovation that people say, okay, we must have the law on it. Then you realize, actually, we don't need to. Maybe we just need to enhance the law, and then you see there is a danger or risk if we create the law. Maybe it doesn't really change things. It is not effective. But sometimes we realize the new law is needed. Then you have to highlight that. That is, you see, very fundamental, thinking about law in the cyberspace. Yeah, please read those articles, and also you can relate it with our current conditions because it was mentioned in the past, 1996, 99. But now we have more and more questions about a lot of innovations. Yeah, what is the direction of our cyber law should be? That is, well, it requires a deep thinking, yeah, for this one. Okay, so I will stop here for the first half. Looks like the next topic I cannot really impose for today, which is content regulation. But since I gave you the article, so please read the article after the class, because in the second half we want to hear your presentations. Yeah, 30 minutes from now, inshallah. I mean, after almost Maghrib time. So we want to start a presentation. If it is now, yeah, Maghrib time is when, yeah, not yet. Almost
7, Prof.
at 7. You can actually have a break first, and then so we can start 30 minutes from now, like 7:20 lah. Yeah, 7:20. Yeah. Okay. We'll see you next.
Okay, Prof, inshallah.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam, Prof. Thank you, Prof.
Waalaikumsalam warahmatullahi wabarakatuh.
See you later.
Salam.